They seem to believe in these pre-crimes where just the mere possession of something that could be used as a weapon should be prohibited. And that's the sign of a totalitarian government.
We are the Armed Attorneys. Today we're talking about 3 cases, one very recent case as applied to the Second Amendment and how it isn't just covering firearms, so you'll want to check it out. But before we begin, show your support for the Second Amendment by hitting that like button. And today's video is brought to you by our friends over at Sonoran Desert Institute. Check them out at sdi.edu/armed-attorneys. Take your hobby to the next level with online gunsmithing and armor courses and so much more. sdi.edu/armed-attorneys. Now, we've had this kind of trend of states courts saying, hey, the Second Amendment is not just pigeonholed into firearms. And we have a brand new case out of it, and we got to talk about it. And a couple of these are a little bit older, but even under the standards of Heller, which we're going to start with, the Second Amendment just doesn't apply to firearms.
Thinking about 1791, whenever the Second Amendment was written, the more common arms were non-firearms weapons. I mean, just think about it. Swords, knives, pikes, lances,
Clubs,
maces, battle axes, slingshots. Those were all in common use and common for self-defense purposes. And so thankfully, the Second Amendment, the founders didn't write in something like firearms or somehow other restricted. They just used the word arms. And now that's going to apply to everything.
Yeah, so the first case we want to talk about was Maloney v. Singus. That's 351 Federal Supplement 3rd, 222, if you wanted to check that out. That's out of the Eastern District of New York. It's a 2018 case. And this applied to nunchucks. Yeah,
Yes.
They said that this was covered by the Second Amendment. And they applied intermediate scrutiny under Heller. And so nunchucks covered.
Why wouldn't they be covered?
Well, I think maybe we should retitle this episode Mall Ninjas Win, right?
Well, yes, because the nunchuck is a primary weapon of the mall ninja.
Sure.
It had, of course, a surge in popularity due to the 1970s kung fu movies, in particular the Bruce Lee movies.
Yeah.
Enter the Dragon. That really inspired a lot of people to go out and get nunchucks.
The second case that we want to discuss very quickly was Ramirez v. Commonwealth. This was out of Massachusetts. If you want to check out that case, it's 94 Northeastern 3rd, 809. And then you had another case that related to the same issue. But in this case, the Massachusetts Supreme Court found, relying on that case I want you to talk about, that stun guns, their statute prohibiting stun guns was unconstitutional and in violation of the Second Amendment.
Yeah, the Supreme Court actually ruled that in 2016 in a case called Satano, that stun guns were protected by the Second Amendment, and that even under the Heller analysis, that the prohibition on possessing stun guns was unconstitutional. The regulation was declared unconstitutional, but it just shows that some legislatures have just this inexplicable desire to just go out of their way to regulate any type of weapon. They seem to believe in these pre-crimes where just the mere possession of something that could be used as a weapon should be prohibited. And that's the sign of a totalitarian government.
Yeah. And I was talking to a client the other day. He was traveling to New Jersey, talking about his options for defense. Going through some of their statutes, they have limitations on the size of pepper spray you can carry. So you can't have like a regular pepper spray that would actually work. You have to carry the little tiny keychain ones that are completely ineffective. So, they remove the ability to defend themselves. And that brings us to the really important case that we need to talk about today. That's Teeter v. Lopez. I don't have a citation for you just yet, but this is out of the Ninth Circuit Court of Appeals. Their case number is 20-15948. This came out just August the 7th, 2023. And what did this relate to?
This case related to a Hawaiian law that was put in place in 1993 that said that Hawaiians could not purchase or possess butterfly knives. And, if there's anything more associated with mall ninjas than nunchucks and, of course, throwing stars, that would be the butterfly knife. I remember that whenever I was a teenager, we were obsessed with butterfly knives, trying to figure out how to use them, how to open them, how to look cool while doing it.
Protection.
I mean, it's just a rite of passage. Every teenage boy loves a good butterfly knife.
Yeah, I can recall the number of like little hands cut at Boy Scout camp trying to figure out a butterfly knife. But presumptively, we go back to, and this is what makes this case so interesting, is they're applying New York State Rifle and Pistol Association v. Bruen, our new standard by which we judge Second Amendment infringements, as opposed to Heller. So I think that, I mean, demonstration here, they could have relied on Heller if they wanted to. They didn't even need to touch Heller because we have this new standard. And so going forward, I mean, what do we see? I mean, do you think the state of Hawaii appeals this to the Supreme Court?
They may, but it is very interesting that whenever they were talking about text, history, tradition, the state of Hawaii tried to bring in, I think the earliest regulation of knives that they found was 1837, Georgia law that said that people couldn't carry Bowie knives or other large knives.
Right.
And they actually made a distinction. This is the part I found most interesting, is that while Hawaii said that knives had to be looked at in this broad category of just knives in general, this court actually said, no, 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 we're only looking at pocket knives. And so were pocket knives regulated? And they found that they were not, that butterfly knives are are distinctly different from Bowie knives, and so that they could not be regulated. I mean, it's encouraging that they are going to narrow the scope of the types of weapons regulations that are looked at. But then, does that now say that if a state regulated Bowie knives, which Texas happened to do up until recently, just imagine the Bowie knife being outlawed in Texas. I mean, I can't think of a more anti-Texas thing than the state of Texas prohibiting Bowie knives, but they did. Fortunately, the legislature woke up. However, I fear the day that the legislature swings back to the left and the left imposes all of those weapons restrictions once again. That would be a terrible thing. So hopefully this is not harbinger that Bowie knives and other large knives could be properly regulated under the Second Amendment.
Yeah, but it is worth noting while they found that the statute was unconstitutional, they did remand it back down to the trial court to evaluate for further historical development. They didn't really produce a lot of evidence that this was regulated at the time, the adoption of the Second Amendment. Edwin provided that example in the 1800s, but they're still asking them to go back and do more homework.
That's why the Bruen case was very interesting, is because, well, as somebody who really loves history, we're going to see a lot of cases that are actually going to be very interesting to read, because they're going to be required to go into examining the history and the tradition of these regulations. And of course, the majority of the regulations, they're not going to be able to find any support for them.
No, and in the few examples where I have seen a thorough analysis where they've created these giant, spreadsheets of gun laws or things like that and presented it to the court. I mean, we see when they start. I think it's going to be really interesting when we start getting into that area. And I know this is going to probably ruffle some feathers, but where there are areas where things were regulated at the time of the Second Amendment, carrying firearms in places of government deliberation, that's something that I think there is some historical support for. Don't think that it should be that way, but when we start seeing these rare instances where there was regulation, I'm interested to see how that develops as well.
Oh yeah. Well, I think that what people are most concerned about, though, is just simply having the mere possession of a weapon, being able to carry it on or about their person while they're out and about.
Yep.
I think that if you were to limit regulation to very specific places or very specific instances, that most people would be okay with that. It's just the general prohibition that basically, just because you have a weapon, that opens you up to being stopped by the police, harassed by the
all the
police,
gotcha crimes.
searched by the police. So that's what I think ultimately that's what we seek to avoid, is not giving the police an excuse to hassle people for no good reason.
Don't people hassle. But we
No.
hope you enjoyed this discussion. If you did, consider subscribing, hitting that like button, and help us fight the anti-2A algorithm by sharing this video. And we always appreciate your questions and comments in the section below. Till next time, we're the armed attorneys.